If you could find a doctor say, well, I think it's the vaccines that the kids are. It's just a matter for the jury, for experts to debate and the jury to make a decision on an individual basis without any general acceptance that there is a link between the vaccine and autism.
Well, that's correct. Providing that there is no new or novel scientific methodology, profile evidence, some gadget, that device which can't be cross-examination. As long as it's pure opinion testimony, if that expert is rendering opinions that are just completely specious and have no basis in medicine, it will be ripped apart in cross-examination.
So what's the basis in medicine other than the differential diagnosis that you're arguing?
In this case? Well, Your Honor, there are plausible biological models. We know, I think I can say that there's a consensus. The defense counsel may disagree. There's a consensus now in medicine that this condition involves a disruption of the central nervous system. We know something about it. That more than likely this condition occurs when there's injuries to the upper extremity, the cervical region, not the lower region, which is consistent with the fact that trauma could cause a disruption causing this widespread pain.
But isn't the problem here that the difference that between Fry and Daubert is that Fry still does require the proponent of a theory to put on evidence which establishes that the theory has been developed on the basis of generally accepted scientific practice and principles, and that and until there is a consensus that we have a way to conclude that trauma causes this disease, that Fry would not allow that to be considered by the jury. I mean, isn't that? I mean, that seems to me that's the sense of what Judge Griffin was saying.
Your Honor, the case law put forth by this very court has not ruled that scientific principles means the underlying theory and conclusion of the case. In fact, it's just the opposite.
Well, we get awfully much involved in terminology. We do that because when we say that, it seems to me, what does Fry then stand for? What does Fry? I mean, why do you say that what is the difference between Fry and Daubert under what you're arguing?
Well, the difference between Fry and Daubert, Your Honor, is that Fry requires a general acceptance of the methodology when there's a newer, novel methodology, test, technique, what have you. Under Daubert, you have several factors that are then weighed together. In some places, it's interpreted differently in each state, but in Daubert, you have a number of factors, and one of them is the Fry test. Sometimes it's varied, it's not general acceptance, but it's something else, and a number of other factors weighed in with it. In fact, there's a dispute about whether Daubert is more strict or more liberal. Some more keen observers of this indicate that the Daubert test has actually been applied, is actually more strict than Fry itself. But, Your Honor, I think to go to the deeper part of your question is that Fry is not implicated unless there's this methodology, which is new and novel. There's nothing new about the theory that trauma causes fibromyalgia. The defense's own expert, John Russell Rice, rheumatology, Duke University, authored a book, chapter in a book, 1987, Complex Medical Patient. He has a chart in there, and it's record is page 418 to 422, and he actually lists trauma in 1987, 20 years ago, as one of the things that's secondary to a possible cause you have to rule out when diagnosing this condition. So there's nothing new about it. There's certainly nothing novel about the way and the manner in which the testimony would have been elicited. It would have been just the same way as arguing that trauma causes carpal tunnel syndrome, of which there's a dispute on, but it goes to the jury all the time. Your Honor, a couple of points in the way of rebuttal. First of all, plaintiff's experts are some of the finest in the world. John Romano, Wheeling, West Virginia, was on the ACR criteria that developed the diagnosis for fibromyalgia. He's an author of 2 of the 3 consensus reports, and is truly an expert in the field. Dr. Pellegrino, our expert in Canton, Ohio, has one of the largest fibromyalgia practices in the world. He's authored many books on this topic.
Well, how do we
respond to the Nebraska case in the portion of the opinion? He says supports the position that that aspect of the opinion essentially says that this evidence would not be admissible under a Fry standard. As far as that element of the Dauber more complex and comprehensive analysis. Could you respond, because he's quoted a very specific part there that seems to support his position. You've given us the Nebraska opinion. It appears that if we're just applying a Fry standard to that case in Nebraska, that evidence would not be admissible.
Yes, Justice Hanson. Each state determines how Fry is applicable. It's not a static standard. And this court has determined that Fry applies to new and novel scientific methodologies, tests. There has to be that scientific device in the courtroom that can't be cross-examined to even trigger Fry to begin with.
Tell us what the Nebraska court had before it, and then what the analysis was of the court, and then what we could look to in that analysis that you've cited to us for help here in determining what the outcome of our examination, whether we should apply Fry, and of course, in a sense, this is like the chicken and the egg, the way you all have been arguing this, as far as what happens if you do apply a Fry analysis. But I'm asking you to really focus on something you cited to us, and your opponent has pointed out may not be as supportive of your position. Can you help me with that?
Your Honor, we cited the Epps case merely as persuasive authority, not as dispositive authority. It was certainly a case that dealt with this issue, and so we felt in good faith we had to cite it to bring the court's attention to it.
Does it say what your opponent says? It says that if they applied Fry in Nebraska, that it would not be admissible. Does it say that?
That is the quote he read. That's correct. But again, the law in this state is not the law in Nebraska. They are different.
I'm concerned with your reliance, though, on the credibility of your experts, because that's really not the issue. The issue, the underlying issue, is that we must test. What is it that must be tested? Right. And you could have the expert that has all the credentials in the world. That doesn't overcome the fundamental requirements. I don't understand why you're saying your experts are so much more credible. Is that in some response to the underlying test?
Only because the defense counsel indicated that our experts were not very credible.
With our help, you've used up all of your time. We'll take the case under advisement. The court will take its morning recess.
Thank you, Your Honor.
All rise, please.